Hi Bayami, how are you doing today? Welcome to the class on International Arbitration Law. The class has been carefully designed and divided into 10 sessions. I will be taking 5 sessions, while Professor Paula will take the remaining 5 sessions. Hi Professor Martins, it is my pleasure to meet you finally. I have read some of your articles, particularly the seminal article on Lex Mercatoria. I really look forward to hearing more about international arbitration. I am so excited. Thanks, Abayami. It is my pleasure to meet you too. So, today, we are starting with Session 1. The title of the first session is General Introduction to Arbitration. In this session, you will learn the meaning of arbitration, the key elements of arbitration, the types of arbitration, and the advantages of arbitration. Since you have read my article on Lex Mercatoria, it appears you have some background knowledge of the subject. So, how will you define arbitration? Thank you, Professor Martins. I understand arbitration as a procedure in which a dispute is submitted, by agreement of the parties, to one or more persons who make a binding decision on the dispute. In choosing arbitration, the parties opt for private dispute resolution instead of going to court. That is brilliant. The definition you provided is very apt. Frustratingly, arbitration is not completely autonomous and free from courts. The parties require support of the judicial system for enforcement of arbitral awards, and, when they need interim measures, in aid of arbitration. The great paradox of arbitration is that it seeks the cooperation of the very public authorities, from which it wants to free itself. I saw that in the arbitration textbook, titled, The Idea of Arbitration, written by Professor Jan Paulsen. This in no way detracts from the upsides of arbitration as a dispute resolution mechanism, particularly the privacy and confidentiality at the heart of the process. You are right on that also. So, let's tease out some of the essential features of arbitration from the definition that you have provided. First, arbitration is consensual and can only take place if both parties have agreed to it. Usually, parties insert arbitration clause in their contracts, in case of future disputes arising under the agreement. An existing dispute can also be referred to arbitration by means of a submission agreement between the parties. Second, parties choose their arbitrators. Unlike litigation, where judges are assigned by the states, parties to an arbitration choose the persons to resolve their dispute. The number of arbitrators vary under different rules. Third, as you have rightly noted, arbitration is private and confidential. Fourth, the decision of the arbitral tribunal is final and binding on parties. It is also easy to enforce. Thank you, Professor Martins. I understand that there are 2 types of arbitration: institutional and ad hoc. Can you please provide clarity on the difference between the two? I read it 2 days ago in the arbitration textbook by Professor Gary Bourne. Parties may in their agreement choose either institutional or ad hoc arbitration. There are various arbitral institutions around the world that supervise and administer arbitrations. These institutions typically have a formal set of procedures and arbitration rules that disputing parties have to follow through the arbitration process. Parties may choose to take advantage of the established mechanisms and procedures offered by the arbitral institution. Can you mention some of the arbitral institutions known to you? I know the London Court of International Arbitration, the International Chamber of Commerce, the Hong Kong International Arbitration Center, the Cairo Regional Center for International Commercial Arbitration, the Singapore International Arbitration Center, the Lagos Court of Arbitration, the Kigali International Arbitration Center, the Mauritius International Arbitration Center, and the Lagos Chamber of Commerce International Arbitration Center. That is excellent. Well done, Abayami. Now to ad hoc arbitration. In this type of arbitration, the disputing parties are responsible for determining and agreeing on their own arbitration procedures, rather than being supervised under the procedures of arbitral institutions. Ad hoc arbitration allows the parties to tailor the arbitration process to the specific circumstances of their dispute. Therefore, the success of the arbitration depends on the skills and experience of the arbitrators and parties' attorneys. Based on our discussion today, Can you now identify some of the advantages of arbitration?
Yes, Professor.
Arbitration can be cheaper and flexible. Although, I understand that the procedural complexities and attendant cost of arbitration is now increasing. Nonetheless, the process is less formal than regular court system. Also, unlike court rulings, arbitration proceedings and arbitral awards are confidential. It is easy to enforce the award, particularly under the New York Convention regime. That is absolutely right, Abayarmi. We will be treating the enforcement of arbitration award in subsequent sessions of the class. It is important to note that as we have institutional and ad hoc arbitrations, we also have investment and commercial arbitrations. The difference between the two is that the former is brought under the framework of a bilateral investment treaty, whilst the latter is conducted under the contractual agreement of the parties. Arbitrations can also be domestic or international, but this class is concerned with international arbitrations, so we will bracket this distinction for now. This appears to be a convenient place to draw the curtain on the lecture for today. I do hope that the class has been insightful and beneficial. It has really been beneficial. I have learned the essential features of arbitration, the types of arbitration, as well as its advantages. Thank you, Professor Martins, for taking out time to teach the class. The pleasure is mine, Abayarmi. We will see next week for the next session of the class. So, see you next week. Thank you, Professor. See you next week.
Watch out for subsequent sessions of the class on international arbitration law. This initiative has been developed by Abayarmi Okubit to teach the public the basics of international arbitration. There are also other series on international arbitration finance and the legal theory of international arbitration.